Why is it showing me like? Anyways, good evening, everybody. Hello, it's Monday night. It's a little different, but we've got an update in some things here, and it's the Karen Read saga. Yes, that's right, guys. Karen Read, her civil trial now begins, and this is the trial. It's already begun, but it's the trial where John O'Keefe's estate. Remember, now John O'Keefe's estate, they can sue Karen Read. And they can sue for wrongful death. And remember, they don't have the same burden of proof. They don't have the same burden of proof as they would in a criminal trial. So they're suing Karen Read. Now, I don't know what they're going to sue because Karen Read's, broke as a joke at this point because she spent all her goddamn money defending herself. But we are going to, I guess, figure some things out and see where kind of the lay of the land is today in regards to the trial. Yes, they still have the same shitty evidence, but remember, it's not beyond a reasonable doubt. We're down to preponderance. Preponderance is 51% versus like 90%. So, yeah. They're just mad they didn't get any money. I'm sure they are. But we're going to see what happens here. We're going to see what happens. Well, some of you guys change your when you guys change your freaking profile pics, it like throws me off because I got to figure out who's who. But anyways, I hope everybody is, if you're new, welcome to the show. I'm Sean, also known as Potentially Criminal. I'm an attorney from the Cleveland, Ohio area. Yeah, and today we are going to get into this here. Will I be even recognizable that JFK is curing autism? You want to talk about the real genocide out there, the Tardo genocide, like, we can't let them get away with this, chat. We cannot look at the back of my hair standing up. We can't let them get away with this. We can't get them away with this. Also, it makes my name really big. So let's get into this, though. Jackman says, what up, Sean? Not much. Hope you guys are all doing well. So, guys, remember, this is in Massachusetts. It's in Norfolk Superior Court, but it's in front of a different judge. It's not Judge Cannoni. So we're going to see a different courtroom. We're going to see a different courtroom right now. And the audio is like a little sketch, but we have some closed captioning on, and we a bunch of things are going to happen in here. There's some timelines. There's some information that's going to get revealed that we haven't heard before. Alan Jackson promised a big old bombshell. And more importantly, Alan Jackson is trying to get into this as a, as pro hoc vice to join the defense team. Like, Alan Jackson's in this to win this. So here we go. Dagmore says, am I really live? Yes. I know this is a bot, but it's like, tired of streaming to zero? I'm like, well, I mean, not zero, but yes, it'd be nice streaming to 10,000 people, but, here we are. Fair Frozen 55 for $5 says the multi-billion-dollar tard wrangling industry won't let RFK get away with it. Mark my words. That's right. JFK is going up against big autism. And so is Trump. So let's get started here, chat. Let's get started. All right. So here we go. This is it, like, picks up. Everybody's sitting in the courtroom. And it's only an hour and so long, guys. So we'll have time to do locals tonight. Don't you worry your pretty little heads about that. But here we go. Oh, here it comes. The conquering hero.
Counsel, I asked the question that you asked, Counsel. He would like to do status first, then the Rule 12s, but he also said to me if you could check your calendars for trial date. All right. Ms. Crocker, are we good to go? You let us know we're ready.
All right, so here we go. This is court, guys. Normally people are sitting around having a joke and a smoke. Hanging out. Now we're hanging out with Karen. We're over on the side. See there. Kids, we'll get to the Saving King. We'll get to that. There are Karen's. Guys, this is Karen's dad. There's the O'Quee family. Here's John's mom, good old Peg. Here's John's brother, Paul. Paul not happy that Karen lady walk away from law building. Paul upset that she found not guilt. Paul upset jury not believe. So we still got more Paul, don't you guys worry. More Paul. Oh no. But there's the O'Quee family. And here we go. It also makes you wonder, why couldn't we use this courtroom for the trial? It looks a lot bigger. Holy Jesus. Compared to the other one, and I've shown you guys the other one. That one was cramped. Why couldn't we use this one for the trial? Guys, this is not the start of the civil trial. This is a pretrial status hearing. This is a pretrial status hearing. The real thing is not started yet. But this is the first televised part of it that we're going to see where apparently shit goes down. So this is not day one of trial. This is just a pretrial. Paul spent winter making taxidermy hats. Jefferson Post says, what is a status hearing? A status hearing is where the judge says, what the fuck are we doing? What are we doing? What's the point? What's the game plan? What's the status of the case? Now, you guys heard them talk about Rule 12? Guys, Rule 12 is the, Rule 12, Federal Civil Procedure, everywhere else. Motions to dismiss. They're making motions to dismiss on the defense side. But yeah, it's a status hearing. Basically, just a pretrial. Where are we at? What's going on?
All right. Good afternoon, folks. Good
afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe et al. Versus C&C Hospitality, LLC, DBA, CF Mccarthys et al. Case is called for status and for Rule 12.
Guys, if you see now, not only is Karen Reed being sued, but CF Mccarthys, the bar that served Karen, is being sued because they served her a ton of drinks. And if you guys remember from the first trial, they talked about all the drinks Karen had. Well, Karen had more drinks, and then Karen had drinks at the Waterfall. So all these bars are being sued for intoxicating Karen on top of Karen herself.
12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well, thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon.
Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defending Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Kevel on behalf of Karen Reed.
Got it. Okay.
Good afternoon, Your Honor. Christopher George on behalf of the defendant, Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay. I'm sorry, you say the Waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor.
Karen Reed also on behalf of Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor. Looking Rose on behalf of the defendant, CF Mccarthys.
Good afternoon.
Okay, that's all the councilors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. Right. So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants. That's going in a different direction, but you're pursuing that sort of on your own?
Right, but I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant, and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay. All right, procedural issues from the defendant. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of...
Okay, so, yeah, the plaintiffs were like, well, nothing could happen until the criminal case ended, and that makes sense. But now what is Karen Reed? We already knew this. She was going after everybody. Tully, Buchanan, Proctor, she's collected scalps. So it's clear that's happening, but they're just bringing up, Your Honor, this isn't the only thing we're involved in right now.
Violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision.
I was going to say, yeah, this guy sounds like he's got a South African accent. He sounds like the dude in Blood Diamond, Danny's, TIA Danny. The Colonel Klutze.
And retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring affirmative claims against Brian Albert, Nicole Albert, Matthew McCabe.
Maybe he's Rhodesian, yeah. They're going to fucking sue all these people? Nice. Suffer Albert, suffer McCabe's. Suffer everybody. They're going to make all of Canton suffer.
Jennifer McCabe and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House are either police or police adjacent who are socially and personally connected, then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond, so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Dillard can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for under extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Agreed. Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We are aware of them certainly from the criminal trial, but when there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right. Thank you. Let's hear from C.F. Mccarthys then.
Your Honor, Federal is similar vote as to Waterfall. We're putting official touches on our discovery responses. The last leg of it is just direct communications from employees in that incident, some of whom no longer work with C.F. Mccarthys, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right. Thank you. Let's hear from the plaintiffs then in terms of the response to the procedural issue that was raised in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would expect.
Not how the court
that-
system likes this stuff to work, folks.
Right, I would expect the courtesy of the meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters.
Think about how fucking wild that would be. This whole thing goes to federal court. We'll never hear about it ever again. We'll have to get all those little drawings. So we don't want that. We don't want that. But notice, they are, can we have a Clyde appearance? Clyde is down in the basement at 2.0 working on stuff. So at some point, yes. But yes, this is getting interesting, isn't it? All the stuff that's going on here. All the stuff that's going on here. Oh, hold on, chat. I just got an email. What is this email? What does this say? What is this email? Okay, that, and then make sure I got this one right. Jury trial. Okay, hold on here. Sorry, they sent me a bunch of stuff. I'm just seeing. Okay, yeah, I understand it's a jury trial. I get it. Yes, you sent me a jury trial notice. What the heck? Oh, okay. They sent a couple different dates here. All right, never mind. Sorry. All right, we're going to keep going here, chat. We're going to keep going. So, let's hit this let's hit this now. My basement bunker is full of spiders. No, it's not. Let's keep going here.
And all of those who are involved believe that they have other legal rights and they want to pursue other legal theories. That's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took place.
It is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So with this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case, and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that there's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards, like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct?
Yes,
There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery.
I'm very impressed with this judge. I don't know anything about him. He's very sharp. We're not here to... Notice none of this Bev Canoni. Oh, I'm going to go drink a margarita. No, he's like, this is what we're doing. I mean, this guy is all business, and I appreciate that. This is light years better than Canoni already. Even if I won't like his decisions, at least I it sounds like I can respect them. It sounds like I can respect them very, very much so. Stephen Cooper, real quick, has been a member for 21 months. Thank you, by the way, Steve. It says, nerd! Hey, Toger the White says for $2, speaking of, are we ever going to get a Suffa emote? Maybe. The Dagamore has been a member for 12 months, says, I wonder if he was in the Sealish Scouts. He wouldn't be. He's too young for that. He'd be a Ricky, though. He'd be in the Rickies. In the bourgeois. So, yeah, but no, this judge sounds great so far. Am I a black lady? How loud? Yes. Can I get a serif emoji? Maybe that too. We'll work on those. So, let's keep going.
Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right?
Also, chat, just so you understand, that's the timeline for a civil trial. Years. That's the timeline we're looking at. You heard him. Judgment by 2027. And yes, Sarah, you could argue that's being optimistic too. So, but yeah, this is not a yeah. Yes, I'm gonna lose a civil trial on that land, bish. Mike says, is this because they have to fit the criminal trial schedules, or is discovery just that long in civil trials? It's this long in civil trials. The criminal stuff, as long as it's being done at an orderly pace, it's not a big deal. Remember, Karen Reed's first trial took 2 years to happen. It's just, it takes a while. I mean, depositions and then all the... I guarantee there's probably going to be at least 20, 30 people deposed in this case. Those all have to be scheduled. All of the paper documents and all of the... I mean, remember, all that stuff generated in our criminal trial is now going to be examined by the civil attorneys. Sure, Alan Jackson's seen it, but that South African guy may not have gotten everything yet. And surely the defense or the plaintiffs are still going through it all. It's going to take a long time. A long time. So here we go. Manny B says that's rated. No, that looks like a husky. So that doesn't count. I like the plaintiff lawyer doesn't get paid unless they win. Well, yeah, that's the thing here. This guy's hunting for a whale, and I don't know where he thinks he's going to find it. So, unless they settle. Well, here's the thing. Somebody asked us earlier, how is this being done? Okay, the bars have insurance, and they're calling the show. They're calling the tune there. Karen's insurance for her car insurance is probably what's being done here. Maybe even her homeowner, if she had a homeowner's policy at the time, more likely her car insurance is picking up the slack here. And they've got their policy limits. And when the attorney's involved in that, how that's all going to work, we'll find out. We will find out here. But, yeah, Karen's not going to settle, but here's a neat thing. The insurance company can settle anyway because they're the ones paying the bill. They can get a settlement if they want to. And then it becomes a disaster when the other party doesn't want to settle. But the insurance companies may want to settle if it's going to cost too much. The bars are definitely going to settle. Tim Beatty saying the car insurance is indemnifying a criminal act. It's not a criminal act. Karen Reed was found not guilty. She didn't commit a crime. But she is liable for the action. Yeah. Defense is within limits unless it's endorsed otherwise. Yep. No, that is not Clyde. That's Lainey howling because she's too scared to go downstairs. And, the bars are probably going to pay out. One of you guys asked a question here and saying, Shredder S07 is saying, sure, the bars aren't liable for the conduct of their patrons after leaving premises. They can be. If you get somebody overly intoxicated, you're liable for that. You created now a hazard. And also, it was known as the Dram Shop Act in many states. And it's the idea that, bar owners are liable when they serve alcohol to people. And, many states have these. I think Massachusetts still has it. Some states have modified and changed things here. But if you sell alcohol to somebody who's visibly intoxicated, you got to show that intoxication led to the injury or harm. So, yeah, you can get all kinds of stuff from that, but it's a very common thing. If you get somebody super fucking drunk, you're liable for it. Like I said, it's called a Dram Shop Act. If you guys want to look that up, it's called a DRAM shop. So, what about pot shops? I mean, if that were like, if you came in visibly like high on weed and then I gave you a bunch of vapes, maybe, possibly. But Afix, you're saying, imagine a bar selling to somebody who's drunk. It's not that you're drunk, but like you're super fucking, you're like the guy's blackout drunk and you just keep serving. That's where Dram Shop stuff comes in. So, yeah. What if Karen admits when home she got drunk? I mean, that might be an issue. I'm sure they're going to try to bring that up. We'll find out. But remember, Karen's off the hook now for the criminal stuff, so she can admit to all kinds of shit now. So let's keep going.
I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could. The clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now. So I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing, but to have two depositions, for example, of parties in two separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. We'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
Okay. All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother. Again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the Wrongful Death statute. And the Wrongful Death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
Thank you. So let's turn to the other defendants if they want to be heard. You filed separate motions.
Now, guys, when it comes to the emotional distress issues, yes, typically you get it because you saw the dead body. You know, they had to go and see John's mangled corpse laying in the snow and his cracked head and his raccoon eyes, missing a shoe. You know, you see the mangled body underneath the semi truck. That causes emotional distress. But learning about it, yeah, I mean, that causes some distress, but it's not the same thing. And I think they have a great argument for that. Now, we're going to see what the other side says, because I don't know this area of Massachusetts law well enough to argue which side's right, but this is a very common argument you'll make in a civil setting. They didn't see it, so they don't have the distress that's recognized the law.
Essentially arguing the same relief, but if you have anything you want to add, you certainly can. The Waterfall?
Yes, Your Honor. Yeah.
Well, the Waterfall's going to make the same arguments. They're like, okay, yeah, fuck all these people. But these are insurance attorneys. These guys don't give too much of a fuck. I'm more interested in hearing the plaintiffs.
Well, just very briefly, I think the distinction here the counsel's making is that these claims, these infliction of emotional distress claims, are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:58 now. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't, from a relational standpoint, close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. It would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from CF Mccarthy's on that. Anything else to add on the motions to dismiss?
No, Your Honor.
No? Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others.
And guys, remember, that's the failure state a claim upon which relief cannot be granted. So you fail to state a claim upon which relief can be granted, and that's all they're asking here, and the judge is just reviewing that. He's kind of going over that for everybody in the courtroom, but also for all of us here on TV, because he's like, fuck, I'm going to get so many retards screaming at me saying, bah, 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 one way or another tomorrow. He's like, I don't need this in my office. So he's just making a basic explanation. And yes, is Karen Reed going to lose these? Yes. But you still make the arguments because you protect your record and your client.
That deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
Thank you, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor. Does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss, the lowest standard, the Brum case. Plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned. JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow. 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness. At around 6 a.m., they rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family.
No, Wob. It's so sad. It's so sad. Double babies. Oh, woo, woo, woo. Woo, woo, woo. Yeah, Turtle Boy, shout out. Guys, yes, Turtle Boy eating Carney. Kicking ass and taking names out there at Turtle Boy Live. But yes, Turtle Boy. But yes, it's so sad to deportate. Should have fucking learned to jump out of the way of the car. Look, how you doing? It's good to see you, man. Yes, blogger. Yep, I know. Such a vile name. Such a vile name. So, do all these accusations need to be proven, or can the lawyers just go through their what? Well, he's laying out what their theory of the case is. So, this is kind of like normal. Is he doing an opening statement during a hearing? It's not really an opening statement. He's trying to fill in the judge a little bit. And he's just, this is strutting their shit for the record. And also, because I'm sure, like, pegging them. Peg's going to go like, yeah! And Paul's sitting in the back going, yes, lawyer man. Make Karen suffer. So that's how they do it. I like how they can slander because it's in the filings. Yes, when you're inside a courtroom, you can slander people because you have defamation privilege. You have testimonial privilege. Yeah, I said Carney. So anyways, here we go. Anyways, let's keep going.
Keefs and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages, the lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for overserving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress as a concept has evolved in the Commonwealth is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. But the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know that.
Now, this is like, he knows he's got it, but this guy's just, I do this too, even when I know I'm safe. You fucking run it into the ground just to make sure you don't fuck this up. So that's why he's really hitting this as hard as he can. So don't get too worried about this, guys. Don't get too worried about this. Like I said, is she going to win? No. But you make the arguments, and it's his job to say that. I know you guys don't like it when he says my brothers and sisters over there. That's how some places that's how you do it. You know, here you might say my colleague, or you might say, hey, Attorney Jones. I disagree with how Attorney Jones, or what you would really, I mean, if I was doing this, I'd be like, look, Your Honor, I disagree with what the defendants are trying to bring here. And you just say defendants. But, you know, remember, every place is different. Every region has different cultures on how you handle things.
Decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone, does not experience the injury, and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions.
We'll get to that.
Suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard.
Guys, NIED means negligent infliction of emotional distress. Karen didn't intentionally try to hurt John, but she negligently hurt John. And she negligently caused and inflicted emotional distress. So they're saying NIED. They're not starting to spell a tower and get lost on their way. They're saying NIED.
To undo of it. It is very different from learning that your close family member has died. that is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom...
So chat real quick. I know you guys wanted your Clyde sighting for today. Here he is. He got his haircut. He got his haircut. Hi, Bubba. Say hi to everybody. Hi. Oh, no. 2.0 walked away. He wants her back. Do you want back down, Bubba? Are you okay here? All right, we'll keep going. We'll keep going. So let's keep going here.
Conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenk, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed the pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly.
False narrative publicly. You have fun proving all this, Home Slice, even at 51%. You're going to have a tough time here, brother. You're going to have a tough time here, but this little tampon waggling this guy's doing here, I mean, this ain't... Where did this timeline come from? This is the timeline the prosecution had. Aaron says, can they mention the other verdict? I don't know in Massachusetts. Certainly, if I'm the defense, I'm bringing it up saying another fucking jury already took a look at this. Although at this point, I don't know how anybody in that area doesn't know this didn't happen. Really, I don't. This is bullshit. I agree, Flux. 100% bullshit. So, I agree, but they're allowed to do this. It's a. Remember, guys. We fit. This is like mile 2 of a marathon. This is like 1.5 miles into a marathon. We're not even close to the finish.
Social media to leak public information through Turtle Boy to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired, and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Pillay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
That was like 15 minutes too long, chat. That was like 15 minutes too freaking long. Holy cow. Holy cow. Yeah, so just blah, 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 blah. So I don't know why he did that. I don't know why he did that. Another says for $5 real quick. Sean didn't deny it. I'm another black woman confirmed. Well, thank you. We'll answer get some of these other ones later here. Johan says that they're all salty. She got found not guilty, and now they're going to go after her and bankrupt her to punish her. Got it. Joke's on that. Joke's on them. Karen's already bankrupt. Karen's got no money. You can't get blood from a stone. So joke's on them. There's no it's like on The Rock. It's like General Kimmel. It's never about the fucking money. There is no fucking money. It's like, yeah, it's all gone. You know, they're like, I don't know what they think they're gonna do here. Like, they can have that busted up fucking nasty Lexus if they want. If they really, 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 really want it, but I just don't understand. Like, yeah, I mean, so now, real quick, and this is something Jefferson Post put together. Yeah, he said here. For bars, it's MGL Part 1, Title 20, Chapter 138, Section 69. Yeah. This is the Dram Shop Act we're talking about. This is it. This is it. No alcoholic beverage shall be sold or delivered at any premise licensed under this chapter to an intoxicated person. That's all it is. That is all a Dram Shop Act is. And you might say, well, that's not enough, but it is. So yeah. Let's just keep going here. We'll get to the rest of these in a second, guys. We'll keep getting to these in a second here. This judge is based. I like him a lot. Oh shit, chat. Shit, chat. I'm sorry. Fuck. Sorry, chat. Hold on here. Oh my god. Sorry.
the third of those
Sorry. I'm
arguments.
watching along on
They
my
should
screen. Sorry,
know
chat.
that plaintiff's susceptibility and vulnerability are at issue in this case, and are
sorry.
the very reason and foundation why it is.
Here, we'll get to plaintiff.
Allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit, part of the car accident, gets up, runs to see his son. It's contemporaneous, it's at the time of the event, and the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for Your Honor. You also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does, and so as a result, there's appellate processes. And so what I envisioned for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case, it's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to sign a trial date, we could do so. I mean, literally, I've talked to the clerk. We could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties, and there's relatively novel theories as I'm hearing it. But nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here. Clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20.
He's pointed out what's going to happen here. He knows as soon as he rules one way or another, there's going to be an appeal. So he's saying this is going to take forever, and he understands that. But he's just laying it out for everybody else. All of you!
20 years old, and they're still going. The clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench that's been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. And of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do it by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do it.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here at Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure.
How many days out do you want to go? 60 days? 90 days?
Yeah, probably 60 days.
50 days? November 21st, Friday in the end of November.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery, and any motions, Rule 15 motions to amend that or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor.
All right.
Nothing with the jury?
I don't think so.
So, guys, if you noticed, there's like another case pending, and this isn't uncommon. I've been in the hearing, the jury's deliberating, and I'm the hearing the court squeezed in the meantime. So that's not uncommon at all. But yeah, here we go, guys. That's the end of the hearing. It's all over. And honestly, right before Turkey Day, yeah. So, interesting says there has to be a homeowner insurance. There was never a car accident. I think there's an allegation that she hit them with the car, so it's being involved. I don't really know. I don't really know how it's all working out. So we don't really know what's going to happen here. We don't know what's going to happen here, but it's been very interesting. And, you guys are like, well, it's civil. It's kind of like, ugh. Well, sometimes it is. Sometimes it's not. Yeah, she was convicted of DUI, guys, and that's correct. Everybody seems to forget that. She was found guilty of driving under the influence, but she was not found guilty of causing a collision. So, you guys you skipped a lot of it. No, we didn't. We did the whole hearing. Unless you're talking about somebody else. Now, has there ever been a car accident where the defendant claims a car accident never happened? Yeah. Yeah. I didn't do it. I didn't hit this guy. Someone else might have. Like, if this one's going to be one of those. What happened to John Cave? Who the fuck knows? Who the fuck knows? Who knows? Who knows? Do we miss the bombshell? The bombshell is they're suing the McCabe's and the McCabe's and the Alberts. I kind of I guess that's a bombshell. We didn't have that officially, but she's fucking going after everybody. I'm not surprised. She's going after everyone. I mean, are you guys really? That's a bombshell. It's like the Trump stuff. The walls are closing in. No, I mean, I kind of thought that was going to happen. I'm surprised it hadn't happened yet. But yeah, Karen's suing everybody. Everybody getting sued. You get a lawsuit. You get a lawsuit. You get a lawsuit. You all get complaints. And also, Suri, that was a very good question. I mean, not normally because it strains credulity. But here, Kieran Reed could say, it's not clear he hit her. The evidence does not support that he was hit. So this is going to be one of those times where it kind of works out. It's going to be one of those times where it works out. I truly think it will. But thank you for that comment here. And we're going to catch up on the super chats and I'll go back to the other questions here. Assholes React says for $5. I love how it's Karen Reed left her home when JJ left her home alone hours earlier. Yeah, I mean, that's... Shh. John went after that leak. He wanted that puss. So, yeah, you notice how they do that. Notice how they do that. Nick Kreuzer for $10. Thank you, Nick. Says earmarked for peens. Assholes React for $5. Says, hey, Sean, we have the same shirt on. How cool. Well, thank you so much. I appreciate that. I appreciate that so very much. Sherry D is a new member. Thank you, Sherry. Oh, there's a cute little pupper on there. Aw, I like that color. Nice little color doggo. Then Assholes React for 10 subs. Thank you so much for your support, your generosity. And Sherry, you too, thank you for your support here. And you know what? That's going to get us on a woo tonight. That's right. Clyde approved. Sherry with 1 sub. Thank you, Sherry, so much. Unknown Hero for 19 months. Just wake up, fat man. Yes, sorry about that, guys. So sorry. It's live TV. It's what you get, what you pay for. But thank you for being here 19 months. Interesting is saying we think he's an insurance attorney. He very well could be. He very well could be. Although, if he's an insurance attorney, he knows he's gonna run through his limits way before he adds all this crap together. So I don't know what's gonna happen there. But I understand that could be the case. I understand that could be the case. And Kat is saying, so wait, so if my daughter dies and through whatever reason someone else finds out before me, is that actually a cause for me to get money? That is ridiculous. At times it can be. The infliction of emotional distress can be also that other people, notifying families, loved ones immediately is always a big goal. Because that could be learning of it through other people. That could be the infliction of emotional distress. Negligent or intentional. It can be. in the right situations. Totally could be. The infliction of emotional stress is weird case law. Ballyvolk is saying this guy definitely does not want to go to trial. I agree. He's a plaintiff's attorney. He does whatever judgment they get, it's not going to be collectible. His job is to get a verdict that'll pay out. He needs a settlement that pays out. A lot of times when you are a civil attorney, if you go to trial, you fucked up. And it didn't go well because you should have been able to get a settlement for what you wanted. But here, I think the O'Keefes are on life ruination. I don't think they're going to settle. It'll be interesting to see what happens. Here. Because if these attorneys can get a verdict, they'll be like, I'm the one who made Karen Reed accountable. That could be a lot of PR. Or they might say, oh my God, the O'Keefes are insane. It won't cut a deal. We're quitting. We'll find out what happens as this case goes on. Let's see here. Did someone write down all those names? Yeah. Bass kicker is or base kicker is saying, is this going to be a clusterfuck? 12 attorneys on this case? Yeah, they all have to be available. Yes, the more attorneys you have, the more problematic things get on a case. Because now it's the court schedule plus their schedules. Let me see here. Bama Loss has 8 attorneys, and he says, oh my God, I wish all these clients had this luxury. Yeah. And it's so weird, too. You hear this judge saying, well, we're going to go to a different courthouse and do this. And once again, you don't do this in Ohio. You have a courtroom. That is where you stay when you're a judge. You don't get to we're going to move across town. Oh, we're moving to another courthouse. And no, there's one courtroom. That's your courtroom. You don't get that. This stuff here with these, I get it. Massachusetts is 400 some years old. So you've got this issue. They also have a unified court system. I just don't understand how you could bounce around all these different places. It makes no sense to me. And I'm sure even if somebody like David Yannetti could sit down and explain it to me, I'd be like, this don't make no sense at the end. It would still sound very dumb to me. And you know what? That's because I'm an idiot. But also, chat, look how white I'm getting a lot of white in my whiskers now. So people quit saying I dye it. But it's so weird how this stuff works over there. I don't get it. I do not understand it. Havy King says, can she countersue them? This is a good question. You have to sue them for what? Abusing the process? I think that they have the right to say you are responsible for his, their theory is not without merit. It's a meritorious claim. Did she cause the death of John O'Keefe? She was found guilty of driving drunk that night, so she could have done it. So no, she could try, but I don't think she's going to get anything out of it. I don't think it would go anywhere. I don't know what she would sue them for. But it's a very good question. Very good question. Mother Oates says, so that one bar have to admit they don't make their drinks strong? Yes. That might be an argument for them. We intentionally serve drunk people watered down drinks. The problem is if they admit that, their liquor license is in trouble because you can get in trouble for doing that. If you have a liquor license, that's something they frown upon, fucking with the drinks. So I don't know what they're going to do. Nova's saying that's about $50,000 an hour in the courtroom. No. I bet some of those attorneys are $500, $600, $700 attorneys. Some of those attorneys are $300, $250, well, actually it's Massachusetts. I think it's maybe $10,000 an hour in that courtroom. If I was in Ohio, I'd tell you a lot of those guys are probably making $300, $400 an hour. So not sure though. But you guys, these are some really good questions. Please, and if you guys are new, ask away. Those are some really good questions we just got through here. Mega Dude for $2 Australian doodle says, what did you think of the Charlie Kirk Memorial service? I saw it. I did not. I didn't stream it. I kind of didn't feel like it was my place to do that. Parts of it were very, very good. Parts of it were amazing. Erica Kirk coming out and it looked like WrestleMania. I was like, as long as she was okay with it, fine. But no, I will say JD Vance coming out, that was amazing. Stephen Miller, not impressed. Trump, yeah, but JD Vance stole the show. Erica Kirk did a great job. I'm not a big fan of the rock concert Jesus stuff anyway, on the the Protestant side of things with the evangelical, I love you, Jesus, bow now. Like it gets to be a bit much for me. I'm a Catholic at heart still. So, but overall, I mean, it was great. I think people don't realize what the fuck they've done by just being assholes. I don't think people realize the fire that's been started. But thank you for that, bot, Omega Dude. So they're all salty. She got found now guilty. Now they're going to punish her. Yeah, I could see that. I could definitely see that. Happening here. Chinny's been a member for 17 months. Says, why can't they sue the bar for overserving John? Because it didn't matter how drunk he was. He got hit. Their argument is a undrunk person would have been ran over by the car as well. So John's intoxication doesn't matter. Karen shouldn't have run him over is going to be the argument. But suing them for John would, I get what you're saying. Why aren't you suing everybody? But that would look really, I think everybody would sit there and scratch their heads and say, huh? I understand the theory here that if they hadn't made him intoxicated, he would have jumped out of the way or he would have took the keys. But ultimately, that's not, you don't go down that road. It's Karen was too drunk, and because Karen was too drunk, she hit John and killed him. Because if John was sober, she would have killed him too, is their argument. So I get it. That's a very good question, but it wouldn't get you anywhere. It wouldn't get you the mileage you need. But it's a good idea. And thank you for being here. 17 months, Chinny. I appreciate it. Let's see here. Where are you guys at too? Can she countersue for attorney's fees? Oh, 100%. Well, that's not even a countersuit. Some states it may have to be a counterclaim, but normally you're going to ask for attorney's fees at the end if you win. Winter Soldier said, I didn't watch the Charlie Kirk Memorial because it was the Browns humiliating Green Bay. Well, yeah, I honestly know. I watched Charlie Kirk 2.0 can tell you. I spent a lot of time just sitting here and watching it. And, that said, though, oh my God, 9 hours of it, Jesus Christ on a cracker. Was ridiculous. Yeah, standing around singing Christian rock songs is not going to make me a better person. It's not. But I do think the message from a lot of people there was actually very important and very fulfilling. And I think people really did put on I think, do Charlie justice. And they really did, celebrate the word of God and, bring glory to God. I think there were some people who did. There were some people there that not so much. I mean, really, when it comes to it, is I think Stephen Miller's Jewish. I'm not expecting an Israelite to bring glory to God at a Christian man's funeral. But like I said, JD Vance, I thought did amazing. Erica Kirk did amazing. I really think when JD Vance was talking, he was really channeling it. He was a vessel for the word. So. Aaron says they're arguing they get hit by the SUV that did not hit him. Well, remember, it wasn't it was to the reasonable beyond a reasonable doubt standard. It wasn't proven, but maybe it's proven to the 51% standard. But yeah, she can countersue, but she can ask for attorney's fees. John Coleman for $2 says Trump found a cure for the autism. You're cured. No, you're not taking this from me. We are not having an autism genocide. No, I will fight. HM says, wait, you're a papist? Yes. Yes, the Holy See is all that matters. There is only one Bishop of Rome. Yeah. I knew there was something off about you. Avoid the choir boys. We didn't have a choir in my church. I was an altar boy, though, from 4th grade all the way through high school. And even when I was in college, I came my freshman year, Came back a couple of times, and Father was like, can you fill in here? I need some help. And I was like, sure thing, Father. Took care of it. So Bella says, why does it have to be stuffy and old lady singing off key to some people? Because that's how some people want to do it. But if you want to go have Rock Concert Jesus, go have Rock Concert Jesus. I'm just not a big fan of it. I'm not a big fan of it. What happens with all these lawsuits? The conspiracy members get charged. Ooh, that'd be that's here's the thing. That's not happening. As much as I want it to happen, chat, it's not gonna happen. Ain't gonna happen. Like, I'm just telling you, ain't happening. Like, if we're as Master Sergeant Strange, when I did ROTC my freshman year, said if we're a fifth, we'd all be fucked up by now. And that's true. That's true. Like, that ain't like on the list of things that are gonna happen, that's like number 500 right now. List of things that are gonna happen, like, ain't gonna happen. Like that's it's not happening. I mean, I'd love for it to happen, and that would be great. But yeah, that would make things very awkward. But I don't think it's gonna happen. I don't think it's gonna happen as much as it should. So let's see. Confirm Sean is white. Yeah, I'm Santa Maxing. Thank you, guys. Let's see here. Trying to see. I'm catching up. I'm sure John is looking up from hell thinking, what morons have I for family? See, I don't think that's fair. I don't think John O'Keefe's in hell. I'd like to think he was a man who believed in God and accepted Jesus as Lord and Savior and, made his way up to heaven. So let's see here. Sean, thoughts on the guy's accent? Oh, I thought it was a 10 out of 10 South African accent. Jim Cox says litigation in the U.S. is just weird and abused. Yeah, but it allows, in most countries, if you're poor, you have no right or ability to really file a lawsuit. So it still allows the average man to go in and seek justice. That's the beauty of our system. Let me see here. Let's see here. Is that my persona? No, that's something they put together. Job well done says, who's AJ? That means Alan Jackson, Kieran Reed's attorney in the criminal case. So, John O'Keefe is Boston Irish. He's guaranteed to be Catholic. That too. Yep. Sinclair is still preempting. Yes. Apparently Jimmy Kimmel's coming back, but Sinclair Broadcasting's like, we ain't going to show it. But hey, you know what? When somebody goes out and starts shooting up TV stations, I guess they kind of bend the knee. So when you start shooting at ABC stations, they'll start giving in to the mob. Let's see here. See if I miss anything else. Yes, there are many autism, but this one is mine. Yes, let's classify all the autisms. You have your autism, your autism, your. Oh, let's see what else we got. Bella says a bunch of people already take this for autism. Yeah. Debbie O says a funeral mass is only an hour-ish. Go Catholics. Yes. I used to do funerals all the time when I was in by the time after a couple years in, I was like one of the my brother and I, and then a couple of us were like the A squad altar servers. And yeah, we would get called in to do weddings, but I got called, I did a ton of funerals as a kid. I sat through a million fucking funerals in the Catholic Church, and it's a little different when they do the funeral. It's it's normal mass, so there's a bodies, and that's the thing. If you guys aren't Catholic, wedding mass. Do you have a wedding in the middle of mass? So you do all the normal stuff, and then you have a wedding in the middle. But when it's a funeral, you have a funeral, and there's a body right there in the middle of it. And you're like, this is fucking weird. It's a little weird. But thank you, Debbie, for $5. Yes, go Catholics. Yes. Can set your watch to those things. Saying 240SX saying like 2 or 3 songs, it really wasn't a Christian rock concert. I know, but like some of the songs were, and then they had that weird music, that kind of filler music in between. That's like the filler music that, you know, like Christian churches play when they're showing their slideshows at the beginning before their service begins, or if they're on YouTube and they stream, it's the music that plays in the background. It's that, like, it's hard to explain, but yeah, I just don't like the rock concert Jesus stuff. And also, I'm not going to lie, Lee Greenwood, and I get it's a memorial service or celebration of life, so it wasn't really a funeral, but like Lee Greenwood coming out and singing, I was like, like the cringe was real, like the cringe meter was like, and then it almost peaked, and then it went, but it was really high. It peaked out for a second. It's like Chernobyl. Like what did the reading on the machine say? 36,000 kilowatts. Oh. Karen should offer the settle if they pay her attorney's fees and drop the suit. They're not going to do that. Sean thought Carr fired Kimmel. Well, it sounds like the fact he Brandon Carr, the head of the FCC, dabbing and going like this. Jimmy Kimmel lost. Bye, you're fired. And went dab. And then, you know, everybody's like, well, I guess he was involved, so we're going to back down. And then it didn't help some left-wing guy shot up a news station in Sacramento. But yes, he interfered. He stole the glory for the administration, and then it kind of like ran from there. So, Chloe's not a bad dog. She's just misunderstood. Yeah. Oh, did they fire him and bring him back? I don't know what they're gonna do. Yeah, it was a temporary suspension. We'll see what that means at the end of the day. Because they're still going to get rid of him because he doesn't make any fucking money. Yeah, then Lee Greenwood saying to introduce Trump. Yes. Lee Greenwood didn't bother me. I don't mind Lee Greenwood. I'm just like, why did Trump need his own intro song like that? I was like, come on, man. Like, if you're going to walk out like the chairman and just be like, if you're going to do that while the sparklers are going. But come on now. Oh. Everett Scott says, remember when Sean was reading about the FCC? Yeah, because I didn't. He dabbed on it and caused problems that enough people can now wonder. I had a lot of concerns. Imagine that. I'm concerned about the government overstepping. Yes, it was an unforced error. I chalk up any of the weirdness to the fact it was a Protestant service. Yeah. I need walkout music. Yes. Jimmy Kimmel's as cringe as Sean is being right now. You have no goddamn idea. Trust me. Manny, you didn't know that there was you didn't know this? Yeah. In Sacramento, California, the ABC station there got shot up by a guy. He shot a couple of rounds into the windows, and he's like a big union guy. So. You got off work and you have a fun watching Sean live react. Yeah. Oh. I don't know what my walkout music would be. They said they did the fireworks because that's what they usually do, and they thought Charlie would have wanted it. And that's fine. If that's what Charlie would have wanted, then I guess I'm cool with it. Like, if that's why they did it, I mean, I guess. I'm just saying it was kind of a little like, but you know what? If that's what Charlie wanted, man, like, I get it. It's too bad he didn't have his like funeral already planned, but like, I'd have been like, okay, cool. Whatever Charlie wants, he does. So you lived down the street from that place back in the day. Wow. Nusser's son saying how the guy who shot up the TV station got a PR bond is crazy. It's California, man. Everybody gets out. Everybody gets out. Unless you're like, like it all depends on who you are. It all depends on who you are. So, but you would be, your walkout song would be 3 a.m. Eternal. Bob is saying, does it seem like the left is ratcheting up the crazy on X lately? Yeah, I mean, like, no, so more than normal. It's just you never noticed it before. You weren't like, it's always been there. So, unless you're a Republican, you walk in California. Oh, and what's the name of the UFC guy who shot up the car? I'm trying to think. What was his name? Fudge Sickles. Try to remember. No, not Batista. No, the guy who actually did. Frick, what's his name? Cain Velasquez, yeah. Cain Velasquez. Yeah, he's leaning more right. But yeah, he shot a guy who's accused of being a pedophile. And, diddling his kid. And he had to sit in jail for months before he got out and posting a massive cash bond. And Debbie O says, my grandfather planned his own funeral years before he died. It seemed morbid when he was alive, but it was really useful when he died. Yes. That does help a lot. It does help a lot because then nobody fights over what's going on. And you just easy. You walk to the funeral director and you go, do this. And they do it. Chitty says, I just called my dog Sean by accident. I don't know if that's a good thing or a bad thing. Oh, real quick. Waffles. You asked this and I didn't. I was going to get to this here. This is a good question. Does this being a civil case, is Karen stand a better chance of admitting evidence that Bev blocked? It all comes down to the judge. I don't know anything about this guy, but it sounds like he's already just a lot more on it. It sounds like he's a lot more about like doing his job. So I'm gonna say I want to hope so, but I don't know. I'd like to think he will, but we found out how often we've been embarrassed lately, so we might fall for it again, chat. We might be falling for it again, but I'm hoping so. But the rules of evidence still apply. Rule 403 still applies. All of the rules of evidence still apply as far as how do you admit evidence? Is it relevant? What is it and what are you trying to do here? So it really all depends. It really all depends here. I just, relevancy still has its limits. That's a very good question. Haven King says, well, I guess the Alberts can sue Karen for damaging their grass at this point. I don't think they can. They probably would have a statute of limitations issue by now. Because remember, nobody else is sued. So I think they're shit out of luck. But I get what you're saying. Yes, damaging our property would be an actual thing you could sue for. You rutted up my property and I had to hire a landscaper to come in and spend $600 to fix it. Those are damages. The amateur iconoclast says, remember chat, terrorism works. Apparently it does with ABC. John Coleman, who's been a member for 18 months, says, when will RFK find a cure for gayness? I don't know. He's like, we got to get the autism cure and really get it. So we'll find out. Thank you for being here. 18 months. And then DF88 says, it's disgusting how much money these people piss away. Who are these people? I don't know who are these peoples. Trying to figure out there. So Dolly says, will I ever be able to FOIA Macron's evidence? Some of it's going to be under seal if it's sensitive medical information. But yes, is there going to be a picture of Brigitte Macron just doing a squat and there ain't no willy hanging down? Maybe. I don't know. It all depends. I found a cure for the Greys. Yes, I have found a cure for the Greys. So, let's see here. Jim asking a good question. Is Alan Jackson pro hoc vice because he's not licensed in Massachusetts? Yes, that's why you're pro hoc vice, because you're not licensed there. Or is it just a formality because he's not lead counsel or something? No, he is entirely whether you're the lead attorney, your co-counsel, your first chair, second chair, doesn't matter. If your name's showing up on a pleading, you have to basically reality. I mean, not necessarily to get inside the bar, because you guys saw where Alan Jackson was sitting inside the bar, but and I'll just bring this back up here because we need to bring up these pictures. I'm going to bring up a shot of the courtroom here. Hold on. Yeah, here we go. Here's a good example. So this is like in a lot of courtrooms, there's still more room. There's like a bunch of chairs here, and here inside the bar. And remember, chat, this is the bar right here. So that's why you're called a barrister, because you get to go past the bar. You commoners have to stay back over on this side, but we're allowed to go inside the bar and cross the bar. Now, if he is like consulting or advising or merely assisting, but in an unofficial capacity, he could probably get away with sitting here. But if you're at the table, or your name shows up on a filing, you have to be licensed to practice in that state or pro hoc viced in. And I think his pro hoc viced is still good, but he probably he'd actually practice pro hoc viced in. Well, I don't know how Massachusetts does it. If you're for a time and is this because it's the same client? Does he? But he's going to have to the court's going to have to let him in. It looks like he's in. So just because he's there doesn't mean it's automatic. He still has to apply. Peach Cobbler. Peach Cobbler's really good, by the way. It says, can I get a lawsuit? I'll give you a full plate. Oh. And Stacy says, Attorney Sean can help you plan your funeral or estate. Yes. Yes, I am an attorney, and I do that. I do that stuff. And if you have parents, tell them, get your estate plan, because it'll make it easier for you when they die. But what if there is a Willie for Brigitte Macron? I don't know. That'd be hilarious. Anna Wall says lead attorney. Alan Jackson isn't a civil attorney. It's why he's a first chair. I think he does a lot of civil work. It's just not as this is a little outside of what he may do. But either way, even if you're at the table and your name's going to appear on things, you have to be admitted to that area. Jefferson says, I still remember Matt for Fudbusters telling you he does a pro hoc and just does the work to get admitted. Yeah, it's because a lot of people like to save money, but yeah, it's trivial amounts of money. Like the states all around me, I could pay a couple $100 and I could get admitted to like 3 or 4 states immediately. So, just because a federal agent killed a man doesn't mean he's guilty. Yes. So let me see here. Yeah, my dad went to a trust and estates attorney that did it for a flat fee, and that's all she does. Yeah, there are a lot of attorneys who just only do that, and it's because there's a gajillion boomers. Yep. Let's see here. Get licensed in Minnesota. I don't know. No, I don't need that. Remember, chat, you don't touch the cow, and you don't tempt the fates. You don't tempt the fates. The fates love nothing more than the felt people who tempt them. They love nothing more. Read your classics. Read your classics, chat. Don't ever tempt the fates. Oh, my glasses are all blurry. So. All right, guys, with that said, we are all done for now. We are going to get ready for the local show. If you guys are new, potentiallycriminal.locals.com. We do the Monday night show. You guys remember we do that Monday show only for supporters. So it's $3 a month. Pay for 10 months, you get 2 months free. Or if you use the promo code summertime 2025, you guys can get 1 month free access to the Monday night show and the Thursday night show. We got a lot to talk about, a lot of funny stuff to talk about, and we're gonna chill and hang out. Yesterday, 2.0 and I, 2.0 was like, kind of woke up. It's like, hey, let's go do something fun. I'm like, what do you want to go do? And she's like, let's go to Niagara Falls. So yesterday, it's only like 3.5 hours away. We got in the car, drove to Niagara Falls, and very fun time. We'll be talking about that, go through some of the pictures, stuff like that. But yeah, it's a lot of fun, and you do it when there's not a lot of people. Like this time of year, there's not a lot of people there, so it was actually kind of nice. But we went, and it was a lot of fun. It was a lot of fun on Saturday, so we'll be talking about that. I should have met up with Clearwater Chad, and yeah, he's in Buffalo, isn't he? Yeah, in Buffalo. Read us the Antifa EO, so we're not disappointed like the H1B EO. Well, has he released it yet? Hold on. Is there oh, he did it. Oh shit. Wow. Okay. Wow. It actually happened. It happened. Do we get what extra content do we get over on the modeling bench? Not a whole lot there. Did we elope? No, we did not go get married. We had we had a friend come with us. So no, we did not go get married. We did not go get married. So Erica Thorpe says, all night chat, use a promo code summer 2025. Yeah. Thank you, Erica. Would I do a new stream for this? Yeah, you know what? I think we might. So I just looked at this. There's not a whole lot here, but we'll get to it. I mean, because like here's the deal. Here's actually, we'll do it right now. Chat. We'll do it right now. So here's all this is. This is all just blah. It's fluff. So Antifa, also known as Antifascist Action, is a militaristic anarchist enterprise that calls for the overthrow of the U.S. government, law enforcement authorities, and our system of law. It uses legal means to organize and execute a campaign of violence and terrorism nationwide. This campaign involves coordinated efforts to obstruct federal laws through armed standoffs with law enforcement, organized riots, violence assaults on immigration and customs enforcement and other law enforcement officers, routine doxing and threats against figures. They recruit, train, and radicalize young Americans to engage in the violence here and suppression of political activity, then employs the elaborate means and mechanisms to shield the identities of its operatives, conceal its funding and operations in an effort to frustrate law enforcement and recruit members. Individuals associated with and acting on behalf of Antifa further coordinate other organizations for the purpose of spreading, fermenting, and advancing political violence and suppressing lawful political speech. True so far. This organized effort designed to achieve policy objectives by coercion and intimidation is domestic terrorism. Okay, cool. Designation as a domestic terrorist organization. Okay, notice here, guys, this is the big thing here. It's a very simple question you need to ask yourself when you see this. What law is being referenced that allows them to designate them a terrorist organization? Literally, this is like him doing an EO saying the moon is made out of cheese. Okay. So this doesn't do anything. This doesn't do anything here. Yes, and Jefferson, yes, what are the statutory teeth for this? There are none. There are no United States Code. There's nothing in the CFR. Code of Federal Regulations, the Federal Register. There's nothing. What law or rule allows for this? He says, because of the aforementioned violence, I hereby designate Antifa as a domestic terrorist organization. Notice that's not defined anywhere because it's not a thing. All relevant departments shall utilize all applicable authorities to investigate, disrupt, and dismantle all operations, especially those involving terrorist actions, conducted by Antifa or for which Antifa or any person claiming the act is there. So what does this mean? That this literally means nothing. Means nothing. Nothing. This means nothing, chat. It means absolutely nothing. Yeah, the executive branch can tell them to focus on, but there's nothing there. There's nothing like, go after them. Okay, we already were. Cool. It's like Homer when he's got the nuclear reactor guys. Like, can you guys work harder? So it's just a show, yes. But does it mean something? No. No, it does not. It means nothing. Pork gets a raid, yes. All right, so there's more here, guys. We're gonna finish this up real quick. So he says, conducted by any person on behalf of Antifa or any person claiming to act on behalf and funding provisions. Notice it says general provisions. This order shall be implemented consistent with applicable law. This order is not intended to and does not create any right, benefit, substantive, or procedural or enforceable in any law and equity by any party against the United States or its departments or persons, agencies, officers, employees, agents, or any other person. This shall be published in the Federal Register. Like, literally, this doesn't do shit. He just says it's like if he wrote it and said they're cocksuckers. Okay. They're cocksuckers. What does that do for us? Nothing. So, remember, guys, this is the biggest question here. When you see this stuff, regardless of who's president, what law am I enacting? You know, whatever it is. And there's nothing there. There's nothing there. Yeah. He's just basically telling him to go after him. So, nothing there, chat. Nothing there. We'll save this for Thursday, but it's a nothing burger. It's nothing. It's bullshit. It's gay. Erica says, sorry. Summertime 2025. Yes. Amateur Iconoclast says, but Biden told us it was just an idea. Yes. And Three Beers has been a member for 11 months. Thank you, Three Beers. And this is actually correct. He says, I proclaim that Whiskey 77 is a turnip. The same effect has been accomplished. The same binding legal effect has now been established. It's impotent. Yes. So, for now. So, yeah, it's not, it's not like he's saying, I'm sending, I'm not sending JSOC to go hunt down Antifa cells or here's a list and they're clearing it off. No, they're not doing that. So this is relevant. Worthless. Nothing important. So, yeah. So, sorry to let you guys down like that, but yeah. So, with that said, chat, did you read the Destiny motion to dismiss yet? No, I have not had a chance. We'll do that probably on. Maybe we'll do that tomorrow. I don't know. Because it's kind of like it's not going to survive because Pixie got the chance to amend, so she's lives to fight another day. I have not looked at it, but it's going to be garbage, I bet. I'm going to take a look at that. Also, the Stuttering John thing. The attorney in that just dropped like a whole other set of motions and stuff. Like some of these lawcow shit never ends. So, but no, I've not had a chance to look at it. We'll do Destiny tomorrow. Or actually, I was thinking, I don't know when to do Destiny. Yeah, we'll do Destiny tomorrow. So, but anyway, with that said, chat, we are going to end tonight. See you guys over on Locals. Remember, summertime 2025, come hang out with us. And yeah, that is it for here. And guys, remember, same time, not same time, but usually like, 7:30, 8 o'clock if you guys are new. We'll be at it tomorrow. We'll be doing the Destiny stuff. And yes, lolcow warfare never ends. And remember, until next time, chat, just because you did it does not mean you're guilty. Take care, chat, and good night. No, why is it not working? Come on, click over.
Weapons, blacksmithing, and
9 p.m. like always. 9 p.m.
models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy Rick hated yelled at?